Welcome to the Property Podcast. Thank you for joining us today. We will be having a conversation with my good friend here, Bryan Hutchinson. He is an attorney, but he specializes in property law. He specializes in conveyancing. Today, specifically, we're going to be talking about the Expropriation Act. We need to just have a conversation about it, a light conversation, but getting into the most important and critical parts of the Act. Welcome, Bryan, and thank you for being here today.
Thank you, Rose. Thank you for having me.
And I just wanted us to go through the Act and see what your opinion is of the Act, given how people have just been frightened by the signing into being a law of this Act. And I just want to hear your general opinion on the Act, the Expropriation Act, that would be Act 13 of 2024.
Well, I mean, I think that the old Act was done in the 70s, and then since then there's been a huge change in the country. So in some respects, it's actually good we're updating the law, and that it's, especially now that we have a constitution and we have a different environment. I think the main cause for concern is this whole, people call it expropriation without compensation, which is technically incorrect. It's actually, the compensation can be nil. And that seems to be the biggest, that's what's causing a lot of concern amongst everyone. And that's what I was, to prepare for this podcast, I looked at the DA's website and they were saying, that's what they were focusing on predominantly. And then they said, no, we want to chuck out the whole Act. And I kind of thought to myself, well, it's a bit like throwing the baby out with the bathwater. There's a need to update all of this law, but you're focusing on one specific aspect of it. My personal opinion is I can see why in certain circumstances it actually makes sense to offer nil compensation. I think probably the one that a lot of people do also focus on, apart from, fears about farmland, is that we have lots of abandoned buildings, particularly in the cities. And if you can't find, you will have the registered owner's details, but if it's a company and it's a company that's been dormant for decades and you can't find out who the current directors are, you can't find out who the shareholders are, there's absolutely no way of tracing them. How else are you going to give compensation? There are provisions where you can put compensation into, we have a thing called the Guardians Fund, yes, which is, when there's deceased estates. But realistically, who's actually going to claim that? So you might even say, you're almost going around in circles. And I think that's why we have a lot of vacant land that's just been abandoned and no one's doing anything with it. And look, obviously there's also what the government's, attitude to doing things. Some will say, well, we could have expropriated. Well, that vacant land could have been developed. Yes, yes. But I do think this is a particular problem that the Act is trying to address.
You're saying something interesting because, what's important to note for the viewers at home as well is that expropriation is not a new thing. There's an Expropriation Act that was in existence since 1975, Act 63 of 1975. Now there's a new Act, Act 13 of 2014. And so it's not a new thing. Expropriation has always been there. And what's important about what you've just said is you've highlighted that this is not an expropriation without compensation act. It's an expropriation act. It's just that it makes provisions for expropriation without compensation in some instances. And those instances, as you've highlighted, is when, for an example, the owner of the property cannot be reached and the development that has to be done cannot be done because the owner simply cannot be reached. And I've worked on projects like that where it is a low-cost housing project. Mm-hmm. The people have houses, they're already living in the houses because the government has built the structures on the ground. But people can never get ownership of the land because government can never get ownership of that land and therefore subdivide it and give the people that live on those pieces of land their own title deeds. So people are just living there as, I wouldn't say squatters because they kind of have permission to stay there, but they'll never have full ownership. And therefore, those houses, those properties can never serve as assets for the people that live in them. So I have had experiences like that where it's absolutely mind blowing that people are living in these properties. They've made improvements to the RDP houses that are built for them, but they can never ever have ownership of those properties simply because there's a person somewhere who abandoned a huge piece of land that can never ever be now transferred to the people that live there. So I share the same sentiments. I think there are instances where government should just have ownership of the property. But then one of the main differences between the Expropriation Act of 1975 and the new Act, right, is that the Expropriation Act, the older one, says public purposes. And then the new Act says public interest. And this seems to be giving people concern. It's making people concerned. Is it a reason for concern, the fact that they've added public interest over and above public purposes? Is it something that you can say, okay, it's cause for concern?
Yeah, I think people. Well, my personal opinion is it's not a cause for concern, and I'll explain why in a moment. But I think why it's causing people to worry is that public interest. I mean, it's written into there, but you see, one of my reasons for why it's not a cause for concern is that that word public interest is already in the property clause of the Constitution. And so in the Act, it defines it broadly as it talks about effectively land reform. It talks about historical disposition. So the idea obviously is that to acknowledge that certain people have acquired land in the past unjustly, if you can put it in those terms. So the whole idea is the public interest in this context is to rebalance what was an injustice. I think, it's public interest is a term that's, in public opinion floated around. And, I think certain bad actors around the world, other governments, not just in this country, have always said, in the public interest, but it actually means in the government's interest or a select amount of it. It's not actually public interest, for the public. But in this context, it is basically to correct past imbalances. And I think that's what's getting people very nervous because it goes back to the farms. I'm sure if you go back centuries in some cases, there was initial injustice. And the big problem is, the current owner didn't take it from everyone. They bought it, either through the land bank or they bought it through their own finances. And just because, a couple of centuries back, or sometimes even just decades, it was initially unjustly ironically, possibly expropriated, because that's what happened a lot of when you had the group areas. You had these things called community development boards, ironically. But what they did, in Durban, particularly my father always says about is it's up by the race course. It used to be there. It was almost like our vision of District 6 insofar as it was a grey area. I think a lot of Indian people lived there. And I actually had a client who even told me this once, and he said, they just the apartheid government just cut off the water and there was no redress because it was zoned white.
Yes.
And they were all kicked out and buildings were razed. But now you look at it, it's lying fallow. So you had what was actually a vibrant, that's why I say it's ironic, it was a vibrant community. And then the community board came along, but it was for a different community, I suppose.
Yes. Yeah.
Sorry, I probably straying off a bit off the topic here. But the thing is that we have, when the Constitution was passed, there was this commitment. So it talks about there in the property clause, a commitment to land reform, is the term I'm going to use. So it's not something that's new. It's been around since the dawn of democracy, since 1990. Well, the present Constitution is from 96, 97. And so one of the ways I look at the Act as a whole, so basically, it's why I started, is that this is just an updating of existing. It's not like it's come out of nowhere.
Yes, yeah.
It's an updating of what was there, but it's also bringing in some new concepts as well, like this concept of public interest, which when we transitioned to a majority democracy was, you might call it the social contract between the peoples, that to say, yes, we recognize that there was a period of injustice in the past, and we're going to commit to, we're going to commit to rectifying that.
But with all that said, is the Expropriation Act the specific act that deals with now the redress, the redress of the past injustices? Is the Expropriation Act that act, or is the Expropriation Act simply an act that says if there are abandoned buildings the government should take ownership of them. If there are any pieces of land, any land that is not being used, land banking, which is a huge thing where people take land and they store it, they don't use it for any purpose. They wait for the value of the land to increase so that they can at a later stage develop it or sell it. So if there are instances like that, the government is saying, okay, we're gonna take the land because it needs to be used. People need, especially in urban areas like in Durban, in Joburg, where there's a lot of people that go into the city to look for opportunities, but they cannot be housed. So I don't particularly see the act as being an act that redresses the past injustices, but it just seeks to have the government acquire buildings. Even if it was a society where there had never been apartheid, it would still make sense for me that the government says, hey, any property that is not being used, we as the government need to take ownership of. That is how I see it. But one of the things that has been interesting that I've heard from one of the best scholars of property, of the law in South Africa, Tembeka Nqaitobi, you know Advocate Nqaitobi, but he says the government already owns 2.5 million hectares of land in South Africa, 2.5 million of land, and that land is in the ownership of government. We need a law that's gonna distribute. We'll need a law that's going to redistribute land more than we need a law that's going to take land into government ownership, if you get what I'm trying to say. So more than the ownership of land being in the government, we need a law that's going to redistribute the land that's already within the government to the people. And what do you think of that?
Well, I think he's absolutely right. I mean, that's one of the things that has come into this is that I remember, when this all started, it was back in 2018, and I think it started with the constitutional amendment. And the DA, perhaps quite rightly, said, well, it's already has all this language in it. But like with a lot of constitutional rights, you need acts of parliament, primary legislation in legal terms. So to me, the Expropriation Act is almost giving the government the tools in certain respects, especially with like abandoned property, or you touched on, I would call it property speculation or land banking, because interestingly, that's one of the grounds. There's 4 of them, and that's actually the first. And when I read it, the act, the first time I'd heard about it, because the media focuses more on it's nil, and then they don't really say under what grounds. So I think part of the problem is policy, really. I mean, it's government policy, and I think that's where a lot of the criticism has come of the current government. Has basically said, well, it's your policy. You have all this government land. You actually already own it. You don't need to expropriate it from anyone, because you'd be expropriated from yourself.
Yes.
Rather develop that land and redistribute it to people who've been previously dispossessed. But I mean, you did make a very good point about people who have lived in places forever, and they've got no, to use another legal term, security of tenure. They are basically occupiers. And I mean, I had a client once when I was doing articles, he lived in Lamontville, and, he could produce these documents from the 70s, because that's what they did in those days. I mean, in those days, it was run by, what do they call it? I think it was the Natives Department or something. But anyway, basically in areas that had been zoned black, they basically said, well, here's a license to live here. It was a license. It wasn't a lease or anything. And the situation has just continued, because it's now owned by eThekwini. And I spoke to one of because what had happened briefly is that there was a bit of a dispute about who could live there. And the client, understand me, saying, well, I went to a meeting, nothing was being minuted, it was just with one official in eThekwini. And then I did try and speak to the person. They were like, no, well, eThekwini will never give up that property. And I thought to myself, why? If you can prove you've been living there for decades,
Yes.
And I know some people say, oh, well, you shouldn't give away, things for free in that, but it is a unique circumstance. It's people who've lived there. They were living there in the first instance, because they didn't live anywhere else, because the government said, if you are a particular skin color, that's where you go and live, or group, as they defined it. So, why is there not a policy where the government has said, okay, we will, they can hold public hearings, and people can, they can give notice to people, and they can say, come along, and, if you object to it, and actually give people title deeds.
Yes.
Instead of just these old licenses from the 70s seems to be the best proof of ownership they've got.
Which is what people still have today. They have permissions to occupy. They don't have title deeds. And
exactly.
Because of some of the issues that we've already mentioned of government not having ownership of the land, they cannot create the title deeds. But I want us to go back to the Expropriation Act again. I want us to look at how it affects an individual, not a farm owner, because I've read the act and I'm not a specialist in law. I'm a land surveyor, that's who I am. But I've read the act, and to me, when I was reading it, especially the part about nil compensation, it got me more concerned about people who own 250 square meters of land, more than someone who owns thousands hectares of land. This being, the reason being that if you own 250 square meters of land, it is easy for government to invest on that land, and with an investment that will easily surpass the value of the land. If it's only 250 square meters, let's take Umlazi for an example. You'll find that 250 square meters costs around 150,000 rands. If the government, by mistake, because we know these things happen, they built an electric substation, small one, inside that 250 square meters of land. After building that substation will cost more than the value of the land. And in that instance, when I was reading the act, it seems like the government can then take the ownership, expropriate that piece of land without compensating the owner of the land. And for me, that's what's concerning, how it affects the general public, how it affects the poorest people of the poor, how it affects someone who's managed to secure 150,000 rands and cannot build at this point because they're still waiting to get more money. So I don't know what your take is on that. And I don't know if when you were reading the act, you also had the same concerns.
No, you raise a very good point. And I think when I read that for the very first time, and because I know which part you're talking about, is that it was actually the first part I was the most, where it talks about the land banking, because that's the first I'd heard of it. But again, I did go back and I read that, and I thought, you raise a very good point, because I hadn't really considered anything like that. The first thing I would say is that it talks about the public interest. So again, the public interest goes back to dispossession. So, my first instinct is, if it's in a place like Umlazi, you say, well, this was a place that was previously zoned exclusively for previously disadvantaged people. This is a previously disadvantaged person who's now acquired land rights. How is it in the public interest to now expropriate that? Especially if it was built incorrectly. Because the same, basically there's a sentence and then it talks about it. It says you have to take into account all the relevant factors.
Yes.
But I think, again, this goes back to the difference, I suppose, between what the law as it is written versus government policy. Because, there's all these hurdles. It talks about serving notices and that, and it's all done through the courts. But the big problem is that if you can't afford a lawyer, how are you going to understand this whole process? And how is it going to be that, especially if the government is doing it for, not the right reasons. Let's just take a blunt example. If there's someone who's corrupt and they're trying to manipulate the process, and I think this is where a lot of concern comes over. It's not really, it shouldn't actually be over the way the law as it is written. It's more, do we have a faith in our government to actually do it for the right reasons? Yes. And do we have faith in the courts that they're going to apply it correctly? I think that's probably, it goes back to trust. Frankly, it's not, I lived overseas, and when I pick up the news and I read it, trust in government is an all-time low, in my personal opinion, wherever you live in the world, whether it's the West or elsewhere. So I think that, my instinct would be to say that there is enough protection in there to prevent that from happening. So if they erroneously built it, because I'm sure as a land surveyor you'll know, yes. Even though it's mapped out where this person's land is, the substation, for example, has encroached upon it.
Yes.
Or they might have built it completely. In that case, there would be an argument to say, well, now you've got less land, the government needs to compensate you, not offer nil or say we're going to take the rest of your land. To me, it wouldn't seem, no court that is looking at it reasonably with those facts should actually say, no, we'll side with the government, you can take the rest of the land.
It qualifies, that piece of land qualifies, in my opinion, with Section 12 3. I think that's where it is, because the land is vacant, so it isn't being used at that moment. There is infrastructure that has been installed by the government. That infrastructure costs more than the value of the land. So it seems to me the criteria to expropriate the land without compensating the owner of the land is met. Now, that substation serves an entire area within Umlazi, and it's only one person that owns that piece of land. So shouldn't public interest be in the interest of the entire area of Umlazi? Because the minute you take out that substation, everyone loses electricity. So should we focus on this one person who has this one piece of land, instead of focusing how removing that substation from that piece of land will affect everyone else? Is that not the public interest that we talk about? Then is it, when you view all the circumstances around this situation, do you not take into account the number of people that are going to be affected compared to this one owner of this property?
Well, I mean, to me, because this is one of the big things in the Act, is that you've got public purpose, sorry,
yes,
and public interest. Now, it seems if you're talking about, providing electricity in an area, regardless of where it is, that's actually more of a public purpose. If you're trying to expropriate land because there isn't enough land to put a substation, you need more substations, to ensure that electricity supply is reliable. To me, my reading, when I look at because it is defined there, public purpose, I mean, the fact it's specifically in brackets, I think it says, including the government's commitment to land reform. So again, this is where it becomes more technical. And unfortunately, you do see this in a lot of legislation where they put this, but then, they could qualify it, but then you could probably have another 2 pages about how this is limited and that. So it often does seem to me the draftsmen of this, they basically say, well, this is how it's going to be. And then it's really up to the courts to then interpret in what situations.
But it goes
apply.
back to what you were saying then. So that owner of that piece of land would have to, in that case, go to court in order for it to be determined whether or not and the municipality will have the funds to take the matter to court. And the owner of the land will not have the funds to appoint an attorney to go to court on their behalf. So then who is more affected? Is there reason for concern for people? Because most people who do not own large pieces of land, so the Expropriation Act being passed, they didn't even care how it affects them. Would you say that those are the people that should be mostly concerned about the passing of the Act?
I suppose, it does go back to where people say, well, where are the guardrails? And I mean, the obvious answer, well, the guardrails are a court. But the problem is, as we all know, that's great. In the abstract, that's fine. But in practice, it means, well, how are you actually going to get a lawyer to understand this? How are you going to get the right lawyer to represent you? I mean, it is interesting to note there are regulations that haven't been published as far as I'm aware. And sometimes regulations, they add more meat to the bones, if you can put it in those terms. So they will get a little bit more specific. So it actually should be, well, especially the examples you're talking about, they should actually put in direct examples of when it would apply for specific things. And that's where more of the policy could guide that. And unfortunately, I think with the fractures in the GNU at the moment, that is probably going to be a missed opportunity because they should actually have a more consensus-driven approach around these things. I mean, because that's what happens. In acts, you have it basically in general terms. That's why I say it's almost like the skeleton. But then when you start to flesh it out, pun intended, to go down, you drill it down to certain specific, you can do that in legislation. Well, you can do that in regulations. That's what's called secondary legislation. And that's where government, because then the relevant minister would consult that. So leaving it up to the courts, it can be problematic because, I mean, you're standing with years and years. Just to add a bit of a side note, we do have this land claims, the land court now. So previously we had a land claims court. And I think, again, that was one of the compromises to try and assuage predominantly white farm owners at the time in 1994, is that there would only be a set period of time to do the land claims. But now, and I think quite rightly, they've said, well, we're going to have a permanent sitting land court because unfortunately a lot of those land claims just basically went there to the land claims court or to the relevant provincial departments and went to see, and they went there to die basically, and nothing's been done. I mean, I know in New Zealand particularly they've got something very similar, and that is a standing court. So my reason for mentioning that is it's a pity that as part of that, it's a bit like with the Labour Court, you have the CCMA. You almost need like a property ombud or a CCMA for land, so that hopefully you can actually, instead of it being, you know, where you have to lawyer up and everything, try and actually maybe build some consensus, because the Act does talk about the government was try and come to an agreement with the landowner on that.
Yes.
But that presumes that someone's doing it in good faith. So in our example, we're thinking about, well, what if a bad actor is coming to this? So that is perhaps, I would say, you know, thinking as we're talking about this, that's perhaps one of the shortcomings in the law. But I think part of the problem, and you're correct in alluding to that, is that when it goes to this backing and forthing and people taking extreme positions, the drafting of these laws does suffer, because I think the ANC has just said, well, we need to get this done. And as I started at the beginning of this podcast, yes, the law needs to be updated. I mean, we've got lots of other pieces of law. The best example is the Criminal Procedure Act. You know, that was passed in the 70s. Okay, it's been amended, so it got rid of things like the death penalty and that, but it's a pre-constitutional piece of legislation. And it's actually a very important thing, because, I mean, criminal law, you know, governs a lot of, you know, our interaction with the state. And it's just is a pity. But I mean, I think to answer your question directly, yes, there will always be shortcomings in legislation, and it'll probably need to be done through an Amendment Act to cover these kind of situations, and more people think about them and as they're identified. But unfortunately, that does come back down to government policy.
But so there might be shortcomings, yes. But what about the intention of the lawmakers? So if you were not South African, if you were outside of South Africa and just looking at this, and let's say South Africa is a country that is monoracial, if that's the thing, if that's even a word, only black people or only white people. When you look at ANC passing the Expropriation Act, what would you think of their intention for passing that act? What would you think the intention is?
Well, I mean, it's very difficult to judge that, because you seem, you know, for instance, I mean, I was reading on Wednesday, I was watching Trump's announcement, and when it comes to South Africa, he says they're doing bad things. So,
yes.
So clearly the President of the United States seems to think, looks at expropriation and says, no, that's a bad thing.
But where did that come from? Sorry to cut you. Because nowhere in the act does it mention race. Nowhere. Like, nowhere does it mention race. Nowhere does it specify that it's going to be farmland that's going to be expropriated. It's expropriation of land. It's not expropriation of farmland. It's not expropriation of white-owned land. So is this not admission of guilt, perhaps, that when we refer to land or property, we only referring to white people? Is it not an admission that in South Africa, wherever we're talking about land, white people feel like, okay, we're talking to them? Because anyone can own property. The buildings that are abandoned can be owned by anyone. Why is it that it suddenly goes to change and be a racial law when there's no mention of race on the act?
No, well, I agree. I mean, the point I was going to make with Donald Trump is that it comes from a certain viewpoint, it seems. I mean, I won't express my opinions anymore on him, I think, because I'd be accused of being very partisan. But I think, you know, Elon Musk clearly was born in South Africa and he went over there, so there's probably some of that. They talk about the PayPal mafia, but I think you're correct that is a perspective. Now, I mean, my perspective, I mean, I spent 20 years living in the UK, so I was holidaying on here, so I've had a bit of a unique perspective on South Africa. And when I talked to people over there, they didn't know as much. But that does seem to be, because we had this whole big international movement against apartheid, I think that's the lens a lot of people see it through. Not necessarily people who are perhaps ideologically aligned with left or right. They do tend to see it in this lens of, you know, this tug of war between black and white, when actually it's more murkier than that. I mean, so me personally, when I look at it, you know, even as my historic, as a white person with a white family and everything that goes with that, when I look at things, when it talks about public interest, in this particular clause, it says, nil compensation can be done in the public interest for taking into account the relevant factors. So in the abstract, you look at it and say, well, this is a legitimate goal because of our history and because of where we are at. It's not taking this whole piece of legislation, as what I said earlier with the DA, throwing the baby out the bathwater. You can't just say, this is an anti-white piece of legislation. To me, that's incredibly loaded. It goes back and things to what people think are how it's going to be misused, probably is the best way of putting it. But again, that's government policy. And some will say, oh, well, it's all well and nice to say, you live in your ivory tower with all these laws being passed. But when the reality is on the ground, this is what's going to enable it to happen. But, how else as I said, we already have a constitution which already talks about land reform. It acknowledges. I mean, the opening part of our constitution says acknowledging our prior historical mistakes, or words to that effect. It's been a while since I read it, but it says it's acknowledging those mistakes of our past. So, I mean, it's not like some people seem to almost think, oh, well, 1994 comes along. We now have a majority democracy. Things could have gone on as normal, but we're just not going to have racist laws anymore. It's a bit more complicated than that. This takes time.
Again, to just go back to what we've discussed, do you see the act targeting farms? Let alone whether the farm is white owned or black owned, do you see the act being a way to target farms? Do you see a way in which the act can be used to target farms, in your opinion?
I think it could only be done in terms of the public interest. So, for instance, if the doomsday scenario that I suppose people like to push around is what happened in Zimbabwe. But that was slightly different because that was effectively land invasions, would be my argument. It wasn't necessarily done through legal means.
Yeah.
People just went into farms and started taking, and it's a bit like all the veterans, I suppose, all the people who supported Mugabe, and they were saying, well, we have nothing now. Mugabe is, him and the people connected to him were quite wealthy. So my point is that was a different cause. Here, someone might try and use the law, but I think if you look at it, again, it says there the public interest, and then it lists these circumstances. It lists about whether it's being land banked, as you call it. It lists about whether there's improvements. Lists about whether it's abandoned. So in the abstract, if you have and let's put it in blunt terms, a successful white-owned farm or a successful black-owned farm, it might have been in the white-owned farm's case that it was, as I said, like centuries ago, dispossessed. But if that is successful, and if there's because it seems like a lot of these is that the people who are historically dispossessed usually make the claim. So the government would have to basically come on behalf of them, almost pick random people and say, go on an aggressive campaign. But I mean, to me, this is almost conspiracy thinking.
I don't see how, again, you're the specialist, you're the law person, but I don't see how then you can bypass the compensation part in that instance, because if the land, it doesn't say that if the land is not being appropriately used. It says if the land is not being used. That's my understanding of compensation expropriation without compensation. So even if it's not appropriately used, as long as the property is being used, can't be then expropriated without compensation.
No, exactly. And that's my point, is that, how is it that people think you can go and start expropriating a productive farm based on this clause? Because it sets out 4 very specific circumstances. Now, what I like about the question that you've raised is about the very last one. I mean, for me, I was fixated on the first one. I first read it, and you did mention that, the land banking. So again, to me, this is people, it's not necessarily as the law is written. People are basically saying, well, the government has an agenda here where they want to go and target white-owned farms. That is a minority view, I think. But it's sort of taken on a life of its own because, as you alluded to earlier, unfortunately, because of our history, people do see it through this lens. And that's where it has been a bit disappointing because, I think on all sides, I mean, it's just what political parties do. They play to their bases. And that's where I think particularly, I mean, the DA particularly, where they say, no, we're opposed to the whole act, I think it was a bit disingenuous, to be honest. And as I said, I'm not, saying the ANC, any party's bad or anything. I'm not offering support or criticism of either one. But that predominantly is it, and I agree with you, is that why are you just focusing, they've zoned on this one particular issue, and they haven't said, instead of saying, like you're saying, well, why don't we just flesh it out a bit more, put some more, if we consider this to be more safeguards. They've kind of just gone on this whole nil is bad, basically.
Yes.
And I think the reason they do that is, as far as I'm aware, there's no country that does have a similar provision. Usually it is always the idea that compensation will always be offered. But I mean, if you look at the history of the world, I mean, again, it's what the law says and what happens in practice. I mean, if we use our own history, the previous act, like it says there, one of the main difference is that it's mandatory. And I went and looked at the old act just before it was repealed, and there was a whole bunch of stuff that had been repealed in 1992. And you go back and you look at that, and then as it was originally in 1970, and it talked about all these various, Asiatic areas. So it was, where it's a bit ironic is that act was, well, we'll compensate people, but it was the tacit intent was, well, that's only applied to white land. There's a different system that's going to operate to non-white land. I mean, it did talk about, but there was a lot of where the compensation was less or nil. So even though they were compensating people, and so my point is that was government policy back then. So unfortunately, it does happen where the law is written, what happens in practice, and that could still happen even if you have the safeguards in place. I think written into the law. Unfortunately, it does come down to whether you're going to have courts which will actually interpret it properly. You're going to have government officials who will actually, apply their minds to the issue. Do
you think we have the courts and the government officials that will do what you're saying?
I think there are some. I mean, I think it's like I remember reading in the even on BBC, because I still read BBC News, having lived in the UK, and like they said, the courts in South Africa are fiercely independent. Now, okay. Without trying to, put the judiciary down, I've seen a lot of questionable rulings, and unfortunately, our courts are very slow, and they are a bit, they're still very paper-based and all of that. But there are a lot of judges that are fiercely independent.
And if that's the general view of the world, we need to take that positive and just run with it.
Exactly. Right? Yeah. And even, I think, again, people like to bash the government, so vicariously they bash the ANC. But, there are plenty of good people in the ANC who want it to actually be done properly. And there will be some people in government, or regardless of what their skin color is, who are like that. Unfortunately, there are rotten apples. But, unfortunately, you have that in every system. There's no such thing as perfect government, as much as we'd like to. And I think, that's where people, and to me, this is where it goes back to trust. Yes, there are alarming things happening, whether it's in the executive or the judiciary. But on the whole, we do seem to have people who are committed to the values that our Constitution ascribes to, which is things like judges making it without fear or favor. All of these things. And it's important to remember our Constitution, it talked about all these values because it was trying to, prevent the mistakes of the past, but at the same time acknowledging that those had happened and there needs to be a redress. So, that's my overall opinion of the Expropriation Act. And every legislation will have flaws. In my own field, we had the Legal Practice Act, and that's already been amended, and people, were crying because it was a complete change. And again, it talks about transformation, and the BE code has been delayed so many times. And there's even been a lot of black attorneys saying, no, why must, I've effectively struggled to get to where I have to be successful. Now I'm going to have to devote a lot of my time providing free legal advice. So there's even criticism, within. But the point I'm making with that particularly is that you have flawed legislation all over. That's why you have amendment acts and this kind of thing. So, and another thing which, the DAs just sort of run to court. As I said, I'm not picking on the DA particularly, but they're the ones who...
Gonna have hard time trying to prove that.
Yes. But, there is a provision in there where it can be, a piece of legislation can be referred directly to the Constitutional Court. Now, part of the issue with this Expropriation Act was it was passed in the previous Parliament before we had the Government of National Unity.
Yes.
But, so maybe they felt that they had to go and rush. They had no other option. It couldn't have been passed over to the Constitutional Court. But, why didn't they at least ask? I mean, they do seem to have... Look, I think where I agree with the DA is that they need to hold government to account.
Yes.
The government has to be held to account. And that's their role as an opposition. But in common with opposition parties around the world, it seems to be a zero-sum game is what they're doing. So, yes, I mean, I'm bringing it back to what you were saying about was there a missed opportunity for consensus building? I think absolutely it was sort of hijacked into this, us versus them, rather than let's try and have a compromise. I mean, and as we started this, and as I just recently mentioned, is that when the Constitution came together, there was always this agreement that yes, we will have to look at land reform. We will have to go back and ask difficult questions and take into account that some land was acquired unjustly. Some land wasn't just, a willing buyer and a willing seller. It was literally taken. And now, obviously, two wrongs don't make a right. And people are concerned, oh, no, well, now they're going to go and just take it unjustly again. But surely that is the intention of this legislation. I mean, it talks about you may not arbitrarily deprive property. It's one of the...
Yes.
So in legal theory, they've put all these checks and balances on. And they've literally copied and pasted a lot of what's in the Constitution. It seems to me that a lot of the fear just coming over is how is this going to be used? Is it actually, are they going to follow the letter of the law, or follow the spirit of the law, or is it just going to be used for the wrong purpose? To me, that's where I think, a lot of the fear is coming. The more I think about it and the more we've discussed.
No, thank you so much for your views on this, and thank you for coming in today. I'm hoping we'll have more of these conversations because property is interesting, land is interesting,
yes.
And it is a very sensitive topic for the most part. Anyways, thank you so much for joining us today on the Property Podcast. We hope to see you again next time. If you found this podcast informative, please do subscribe below and see you next time.